Good morning. My name is Shana Horton. I am the rules attorney at TABC, and we are here today on Friday, September 10th, 2021, for a stakeholder meeting on 6 items, including 5 rule packages and 1 advisory. We have already looked at items 4 and 5 at our last meeting, so this is our second go around on those. But items 1, 2, and 3 are brand new, as is 6. So without further ado, we will get started with new Rule 33.1, computation of time. Just a quick note, we had the wrong version up until about 3 minutes ago. So if you want to go back into Board Docs and reload that item 1, you'll see that it has been swapped out for a newer version. And the difference is that the subsection D2 now refers to the business day rather than a day on which TABC's headquarters in Austin is closed. And that's based on a comment that we got at our last meeting. So I apologize for that last minute switch, but it is correct there now. We will talk now about 33.1, computation of time. We've had a lot of questions about what day and business day mean, because they are used throughout our code in different ways, and throughout our rules in different ways. And then now that we have Ames online, of course, your day and when you file things is a little bit different, because Ames can accept filings through your portals until 11:59 p.m., unlike folks at the regional offices. So we thought it best to just go ahead and put a general rule at the beginning of Chapter 33 that will apply to all of Chapter 33 to make clear what we mean when we say a day or a business day, and how to count days. The rule for counting days was moved up from, it had previously been, or is currently in subchapter E for protests, application review and protests. But we just decided to consolidate that with this rule about, it's all about time, and put it at the beginning. And then we made that tweak, taking out the reference to days when headquarters is closed or open, and changing it out for business days, because that's generally going to be, when headquarters is open, it's going to be a business day, and when it's closed, it's usually going to be Saturday, Sunday, state or federal holiday. Just to keep that consistent. Are there any comments on this rule? Let's open the floor up and hear your thoughts. Anyone raising their hand? You're welcome to unmute yourself and speak. Okay, it looks like Amy Harrison is unmuted.
Thank you. Good morning, all, and thank you for this rule. I kind of feel like should be the Amy rule, because I'm constantly asking about days. I would really appreciate if somebody from licensing could take this rule and work an example with us with the L-TEA and explain to us how that's going to be applied in practical, if we just took an example and worked it together, so that everybody understands the number of days and how they're counting. There seems to be a lot of confusion. I appreciate it.
Okay, we don't have anyone from licensing here today, unfortunately, but maybe what we can do is upload FAQ, or maybe have them address it during a TABC talks. Let me talk to licensing about that after the meeting and figure out the best way to go about that, because I think I understand your concern, and I think that's probably a good idea, and we just need to figure out a way to make that accessible, since they're unfortunately not here today. But maybe we can have it be something written on the website, so it'll remain there as well for others' use. So
wonderful.
Thank you.
I have one other comment, and that is, maybe I was too enthralled with Ames when this was going around the first time, but the minimum of 2 days when there are file in use, there seems to be a lot of confusion around the state. about fall and use. So if I have a minimum of 2 days and I've got 2 funerals, apparently people are requiring to have the owner of premise dedicate the location for one funeral. And because it has a minimum of 2 days, the other person drops dead and nobody's able to get a temporary the next day to bury the next person. So there seems to be a lot of confusion there and about file and use. And as far as catering, one of the things that I've noticed is that in the past, the reason 10 days was chosen, or at least what I was told, was that it encompassed 2 weekends and a week, so that small businesses who were attempting to do these temporary events didn't have to come to the commission twice for an event that took place over a 2 weekend period and a week. Take Pecan Street Festival, many festivals. Well, by eliminating the 10-day catering and putting a 4-day maximum for an event such as Pecan Street, you're now asking those businesses to come knock on the door of the commission through Ames or personal 3 times rather than 1 time, which is what the 10 days covered. So I'm just curious, while we have these rules open, and although this is not something that perhaps anybody really wanted to address, the 4 days are causing a lot of problems for small businesses, and the fact that now they're knocking on the door more times at commission, and the 2-day minimum when it comes to file and use that doesn't even require TABC authorization is also causing confusion locally. If somebody could get those things addressed so that the public as well as staff understand these days, I think it would be very helpful. Thank you.
Y'all listening in, if you're confused, that she's referring to the rules that are in item 3. So we can get to those and talk about them more when we get to that item. Amy, I will look into that 4-day comment, and because I don't believe that that's how it's supposed to work. But it's been a long time since we've worked on that rule, so I'll look into it, talk to licensing, and we'll get you a response.
That would be great. We just need some clarity. I appreciate it. Thanks.
Okay. Anybody else want to make a comment or have a question about item 1, the business day rule? It's pretty standard language for a business day. You'll see it elsewhere in other codes and other rules that you use. I'm not seeing any raised hands, so we will go ahead and move on to item 2. This one I would expect to have some more comments. And I have with me Matthew Cherry, who's going to help me out on questions with this one. As y'all know, we needed to amend the food and beverage certificate rule due to some legislative changes, very recent legislative changes from Senate Bill 911, I believe it was. Right, Senate Bill 911. So this is our attempt to do that. It's sort of a halfway point between what we used to require, commercial cooking equipment, all that kind of stuff that we stopped requiring during the pandemic, but it doesn't go quite as far in that the permanent rule wouldn't allow the service of things like, a bag of chips to count. There has to be some kind of preparation of food on the site. However, something like a charcuterie board is something that is prepared on site. So we're just kind of threading that needle like that. We are also adding the definition of restaurant per statute and incorporating that into the qualifications. So with that, I will be quiet and let everybody make their comments. Does anyone have a comment or question about item 2, revised Rule 33.5. And keep in mind, this would not go into effect until January 1, because that's when that statutory change goes into effect. Ahead.
Yeah, this is Bill DeFore. Can you hear me?
Yes.
I come in under a different name, I guess. My question is how do you figure the food trucks? We've had a lot of questions about whether if they're permanently affixed to the premises. Has that been discussed?
That's still under discussion, is what I've been told. And then would that be something that, I guess what we'd have to do is, once the final decisions have been made at the level, we'll have to determine whether a rule change is necessary, just based on the definition of what is a rule, or if it's something that can be done through guidance or just instruction to the folks in the field. So unfortunately, I don't have an answer for you on that today, but just to tell you that it is very much under discussion, and we are working that out. So input that you have on that would be greatly appreciated. You can send it to me and I'll get it to the right people. So either send it to shana.horton@tabc.texas.gov or rules@tabc.texas.gov, and I will make sure it gets to the right people.
Thank you.
Mark Schwartz.
Can you hear me?
Yes, sir.
Excellent. This isn't necessarily related to the rule itself, but from an enforcement perspective and in relation to wet, dry areas, and specifically areas there where it's not wet for a bar, but only we're wet for a restaurant, is it the position of the commission that someone with under 60% food sales but meets the definition of a restaurant would be able to be permitted with this FB in such areas?
Yes. Yes.
Thank you.
Yeah, that's an or. So if you meet the definition of a restaurant, you're good. Other questions or comments? Marcus, your hand is still raised.
I will unraise it. Sorry.
No problem. Amy.
6A, restaurant, a business that operates its own permanent food service facility. Can you give me some clarity there? The permit holder operates its own permanent food service? Who operates its own? What's its own?
Well, so we have to read it in tandem with subsection C. So an applicant is qualified. Anybody can, a restaurant isn't necessarily just applicable to TABC permitted licensed premises. But if you look at subsection C, how it works in our rules is that if you meet that definition and you're an applicant, then the legislature wants you to be able to qualify for a food and beverage certificate. So it would be the applicant under subsection C. So the applicant would have to qualify as a restaurant.
So in the case of management or concession agreements where a location has Amy that is responsible for all alcohol service, but Matthew, who's responsible for all food service, I would hope that the location would qualify, even though Amy, the permit holder, and this is more to the audit team that, anyway, I would hope that it would be the location is operating as a restaurant and not the permit holder specifically, because the permit holder may have an agreement with Matthew that he's working and doing all of the food. And when I arrive, it's a restaurant. That's just a notation. I think that language operates its own. Maybe if it says operates a permanent food service facility at the location, maybe. I don't know, but operates its own, I think is confusing personally.
Okay, that language was taken directly from the statute, but I see your point. So we'll take a look at it and see if we can clarify that. Okay, let's see. We've got some questions that are coming in on the chat. Is commercial cooking equipment in 33.5 B6A going to be defined? Well, we've never defined it before.
Yeah.
So, I think to the extent that, if you're aware of how it's been implemented in the past, we're going to continue to interpret those words the same way we always have. And I would love to tell you what that is, but I'm not in the field. Do you have any insight on that?
We still don't have a specific definition for anything that's considered like commercial equipment. If anyone wants to send in anything that they have to propose for that, we could work on maybe a definition or a list, but.
Sure. So, yeah, in the patent, I'm not, I don't have a really good handle on what the audit and the field guys have been considering commercial cooking equipment. But nothing's going to change about how they interpret that definition and implement it. But as Matthew said, if you want to help us to create a list of things that qualify or something like that, we'd definitely be interested in hearing your thoughts on that. And we could see if something can be done to help just make that a little bit clearer. Because I know that you're not the only one with that question, Mr. Hughes. Okay. Marcus, did you have another comment? Okay, we have Kelsey.
Hi, this is Kelsey with the Restaurant Association. Sorry, that's my dog whining in the background. I just wanted to note on the operates its own kitchen. I think the intent behind that was to not include, for example, I'm a bar, but I have a food truck in my parking lot. It's a separate business, but I'm going to use their food to now call my bar a restaurant. So just wanted to add that was kind of the thinking behind that language. I get the situation and point that Amy was raising, so hopefully there's some way to kind of thread that needle, but just wanted to provide that insight on kind of why that language is there.
Thank you. That's really yeah. Amber, no. Amy?
I appreciate, Kelsey, the clarity, but it's very problematic out here in the real world when there's beverage companies that form and also partner with food entrepreneurs, because not everybody wants to take on the responsibility of serving alcohol. There's much more responsibility involved in many people's opinions. So although it may have been written that way, the language is going to cause some significant issues, I believe. So it's just problematic, and I think it's wise that everybody know it in the beginning.
We'll see if we can't, like we've been saying, kind of find that sweet spot that does not, that the intent of the law obviously was to, like Kelsey said, was not to allow a food truck to qualify, to make a bar qualify as a restaurant. So we need to do that. But then on the other hand, a concession agreement, that with this food service provider that's going to be in that location doing the preparation, that's a different thing. So we'll have to see if we can find that middle ground. Okay. We have a comment to Amy's point. There are many hotels, private and national chains who maintain business agreements with independent restaurant owners to operate on their premise. All restaurants in this business situation are piggybacking on the hotel's alcohol permit, which causes confusion for Class B and wholesale delivery, as each restaurant wants to operate independently of the hotel. So that's good context. Thank you. Does anyone else care to make a comment or have a question about item 2, Rule 33.5? There's a question under section B3. Is permanent portion of the license location limited to within the building of the designated physical address? It will need to be within the premises. So you're, in your premises map. Don't you? Yeah.
Yeah, within
That's
the boundaries of the areas where
right.
the permit was granted for.
Right. So if you're going to include an outdoor, like I know I have friends in the barbecue business and they have a smoker area that obviously it's cheaper to have it outdoors and have some kind of crazy ventilation system. That would just need to be included in the licensed premises, outline. And that can be amended without too much difficulty for something like that. Marcus.
Yes, here's the exception always drives the rule, but I would note, and you guys have never enforced it this way, but while we're looking at this rule, hotels have a unique ability to serve away from their designated license portions. Most hotels just designate certain areas so that people can freely walk in and out with their own beverages and the like. So this could cause problems depending upon how it's enforced if you're requiring the food service facilities to actually be part of the license diagram. I think it would apply more so to non-hotels. Just want to add that note.
Thank you. Yeah, and we're not, that's not in the rules. So, it's an interpretation issue. So we'll make sure that, that doesn't cause an issue. Talk to the folks who are going to be implementing this. Let's see, Amy.
I just want to, on E, as in elephant, I just want to sort of support what Marcus has said, and I just don't think E is applicable anymore. And it's always caused a great deal of confusion when it comes to inspections and diagrams. So it's probably something that, although I doubt it was part of the consideration, it might need to be struck or redone. It's a problematic area. Thank you.
Yeah, that wasn't really something that we were looking at specifically with this rulemaking because we were trying to do the Senate Bill 911 changes, but that's a good note, and we'll talk about that for sure. Thanks for bringing that up. As long as we're here, we might as well. Marcus?
Nothing on my end, sorry.
Does anybody else have a comment or question or some thoughts on whether subsection E is necessary anymore or should be revised? Give it just another few seconds, and if I'm not seeing anyone, we will move on to the next item. We do have a lot to get through today, so again, if you're not comfortable speaking here or you think of something later, you're always welcome to send an email, or call, but email is really appreciated, because that makes it easier for me to communicate what your comments and concerns are to other people. So, okay, looks like we don't have any more comments on this one. Let's go ahead and move to item 3. This is a package of essentially some tweaks. As y'all know, we adopted the subchapter for temporary events and temporary locations. We adopted it last year, did not go into effect until September 1st. So we couldn't make any changes between the time we adopted it and the time it went into effect, because of, Texas registered standards. So here we are, it's now in effect. And we have a few spots where we have noticed, or has been brought to our attention, that there's some issues that we want to go ahead and get fixed quickly. So in 33.72, we had some caterers and folks like that said, hey, this 10 event limit for temporary event approval and file and use notifications at the same location is going to be a major problem for us. Because we have a contract every weekend at this wedding venue. That's not what we were trying to. That's not the issue we were trying to address with this. As y'all know, we're trying to address a business that uses a temporary location, for example, every weekend, and then they just kind of use it as a second location. We don't want that to continue. When we feel that the location is trying to kind of get around the 2-year permit rule, that's what we're trying to address. So we have exempted public entertainment facilities from the 10 event limit. So if you've got a concessionaire at a football stadium, they're not gonna have a problem. Otherwise, we wanted to limit it to the person or entity owning or leasing a location, so that if you are under contract at a location, that is not going to cause you an issue. Let's just talk about that change for now on 3372. If you have a comment, just go ahead and unmute yourself, say your name, and go for it.
I'm sorry. It's Amy again. Yeah. To me, this is quite confusing. And now, in addition to stopping and asking people to count, which apparently is challenging for many, now they're going to have to determine, do they own the facility? Do they not own facility? Is the facility a PEF? And I don't know how much the commission's keeping up with PEFs. PEFs, a facility can choose to get that designation from the TABC, or they can choose not to. So I'm just sort of curious, if they choose not to, how is the licensing person that's going to work these applications going to really know, is it a PEF or is it not a PEF? I mean, if they've gotten that designation, they can go look at their archives records. If they haven't gotten that designation, but they're operating as one, then they're going to have to say, well, we believe we're operating as one. I don't know the answer. This is very confusing to me.
Yeah, that's why we said meets the definition of a PEF. So if you look at the code definition, and you don't have to actually be designated as one, you just need to meet those requirements in the definition. And if I met those requirements and someone in licensing tried to say you have a 10 event limit, then I would definitely push back on it. And I meet all of these check boxes in 10873. And I should be exempt.
Will that mean that if the licensing tech disagrees with the applicant and the applicant sitting here saying it's a PEF and the licensing person says no, it's not, is there going to be a requirement for the location to now be designated as a PEF? where is that conversation going to go? Is that going to be a denial? Like I say, I think it's problematic.
Probably go to legal for, I mean, it's a legal interpretation question. So, if there's a disagreement like that, they're gonna involve us. And no, they're not going to be required to get that designation.
Ms. Bildeford, can you hear me?
Yes.
Okay, the thing that's not clear on C is the fact that the person that makes the application for the temporary event is the caterer. And the caterer is not going to own the location, but the caterer has to have some reason to be able to be at that location. And that's usually permission from the landlord that he can cater there. So is that going to be considered a person or entity owning or leasing the location?
No, it's having permission from the owner or landlord of the property, such as a contract, it's not the same as owning or leasing. That's really the definition of owning or leasing is just like any other in the property code. So if it's not, we are not considering a contract for use of the facility days and times, or even for certain types of events to be like leasing the property completely. But I can see where that's confusing. So that might require a little bit of work.
And the only reason I bring that up is because part of the TEA and the FUN permits require a letter from the landlord granting permission to use the premises. That's all. That's the reason. But thanks.
Yeah, that we would definitely not consider that a lease.
Marcus Schwartz, Brecken Schwartz PLC, somewhat in line with Bill's comments. Well, I guess this is an interpretation question. Is a concession agreement a lease?
No. Mm-mm.
Not necessarily. It may depend on the specific terms of that agreement.
Yeah. I mean, y'all know what we're trying to avoid. So, the idea is that we don't want someone to lease out a second business front permanently and then just use temporaries over and over again to have a basically unlicensed or less licensed location. So that's not what we're trying to do here. If we need to clarify your rule, we'll look at that. But it's not going to be construed that way. It's not going to be implemented that way.
I will just make a quick comment is I understand where you're going. I had a very similar situation probably 20 years ago in Lubbock where we had an event center that just every weekend they kept doing, Friday, Saturday, Sunday, Friday, Saturday, or Thursday, Friday, Saturday over and over and over again. And we got a call from someone who's on this call saying can't do that. So they made us get a mixed beverage, which I think we all understand that's the reason for that. So anyway.
We've been working on, trying to figure out how to narrow this down to just, encompass those folks that are doing that. And, it hasn't been easy, obviously. So if any of y'all have ideas about ways to word it that would be clearer or address a certain type of situation that one of your clients has, please don't hesitate to send that to me. I always appreciate, especially draft language that could be helpful because you guys all out there know what your clients' issues are and how this translates into real life. So I do appreciate that if you have some ideas. Okay.
This is Amy. Bill, everybody knows it was me that called you. And the way that this was handled in the past and the way that we busted Bill's client was we ran reports. And if you had a report and you showed someone was catering at a location consistently, and then you would pick up the telephone and have a conversation with them and find out what their situation was, and then address them specifically. The good news in those old days, and you know what it is now, I don't, but those situations were easy to catch with ad hoc reports. And the good news was they weren't the norm. They were the unusual. So maybe we could look at enforcement efforts that might be a little more streamlined than this, or rewriting this. I don't know. If I can just finish all my comments on the rule, and then I'll shut up, which I think everybody would be grateful of. D is the nonprofits can go for 10 days. And my only comment there is that that's great that we're being real kind to the nonprofits, but they're also the least experienced at serving alcohol. So now we're giving somebody who doesn't have experience 10 days, and those that do have experience and are in the business are being penalized, and they're only getting 4. The temporary H, a temporary permit or license expires on the date indicated on the license or permit, or on the same date as the primary permit, whichever occurs earlier. That's a lot of words of permit and license. And I didn't realize that these TEAs and funds, and maybe some of them are real licenses or permits. So I don't know if that wording's right or if I'm just the confused person. And that's just an H. And then the effective dates of an event authorization must cover the period in which the alcohol beverages will be delivered or stored, which is a big thing that licensing staff has been trained to express to the applicant. When are you going to get there? When is your alcohol going to arrive? When are you going to leave? When are you going to remove your alcohol? Which is the real reason that I wanted somebody from licensing to count these days, because I'd really like to see how they're going to count them when you're saying that the day of the event or the first day doesn't count. So if I'm getting one from Friday through Monday, if Friday doesn't count, then that's Saturday, Sunday, and now I have Monday. But if it was a Labor Day, that's Tuesday, and I've got to get my alcohol off of the premise on Tuesday after the Labor Day. So now am I getting 4 TEA? I mean, am I getting 2 TEAs or 1 TEA? Yes, I'm making this probably more complicated than it is. But I really think that somebody needs to try to put this to practical application and count the days. That's all I have for 3372, and everybody can say yippee. I'll wait for the next one. Thank you.
Thank you. And I am taking notes. I know y'all are looking at the draft on the screen instead of my face this time. So other comments on 3372. We do need to keep moving. Wow, we need to move quickly. Nonprofit temporary events, 3378. We have added, this should be non-controversial, action only events. What we're trying to do here is, we don't want, the Rotary Club that does, a Zoom auction of nice wines and that kind of thing, or or it just has a silent auction or something like that, and there's bottles of wine in these baskets with other nice stuff. We don't want them to have to get any kind of that's not a public safety concern, so we don't want them to have to come to us first for that, as long as they're not selling or serving alcohol at that event. If it's just going to be given away in the baskets and taken off site, that's not a situation that we're particularly concerned about. And then 3380, we are adding, because we've had several questions in the interim since we've adopted the rules, to, from folks who have previously held events under their mixed beverage permit. And this is to clarify how that works with the new temporary authorizations. Comments or questions on 78 and 80?
I just have one comment on 3378G. Permit holders may sell any alcoholic beverages allowed to be sold where the event is held. Allowed by who? It might need to say allowed by local option election. I don't know. That's my only comment. Thank you.
Okay, that can be clarified. Anyone else on 3378 or 80? Okay, let's go ahead and move along since we only have about 18 minutes here and we have several more items. So 3394, we actually weren't going to necessarily look at this one again since we talked about it at our last stakeholder meeting, but then we realized that what had gotten posted for y'all to view before the last meeting didn't have the red line strikeout. I saved it incorrectly. So we wanted to give everybody another chance to comment on this rule with the benefit of seeing the red line strikeout as well as a clean version. So it's not different from the last time. It's just, we just wanted to give one more opportunity for comment now that you have that particular version with the comments and red line strikeout. So does anyone have any comments or questions about 3394? And I know I talked to Kyle Hill about there's some overlap with 3393. So we're gonna see if we can't maybe eliminate that. We might be able to repeal 3393, but I'm gonna have to look at that. Any other comments or questions on 3394? Marcus. Marcus?
Can you hear me?
Yes, we're good now.
Okay, sorry. And apologies. I think I missed the last meeting on this. So some of this that I'm going over has been covered in one way or another. Please don't hesitate to stop me. My first, I guess, comment is I see managerial control has been defined here. Is it used anywhere in the rule? I can't find it such that I'm not sure why it's defined here.
Well, that's embarrassing. Hold on just one second. Well, I'll move that over from another rule, but I'm not sure
I
how
think
that's
just
used.
effective control is used.
Yeah.
But those definitions did come from
Right.
the prior rule. They've been in there for a while.
Yeah, both those definitions were in the prior rule. I just moved them over, but yes, it doesn't make sense to have it there if it's not used, but what I need to find out is whether that term is used in implementing this requirement. I'll need to talk to licensing about that, possibly also audit. But if that term is not used, we'll lose it. If it is, we need to connect it.
Thanks. And then effective controls definition as used in new subsection J. I have a hard time grasping what effective control is defining here. It's a bit vague in my mind. as related to J. For instance, what is able to direct the general course of corporate affairs? If I have a bank loan to a bank and I miss a payment, and the loan has a provision where that means that I can recall the entire amount due on the loan, the business can't afford it, has to shut down. Do I have effective control over the business? Does a landlord that can padlock a business have effective control over business? Does a governor through a COVID order have effective control over business?
So again, this is one that I just moved over from the prior rule, and it's the one that they, that our audit.
I get that. It's just the new J where effective control has to be done within 10 days. I'm not sure how that's reported when I'm not sure what effective control here in this manner means. I mean, it says they don't have to be a controlling ownership, but can it be a non-owner that has effective control?
Yes.
Okay.
It doesn't require ownership, but and also, I think we might be able to clarify this some.
No, I get it. I mean, the biggest thing for me is like franchisor relationships. Franchisees can certainly do this and could be named effective control, but if you look in the applications, right, as long as it doesn't control the purchase, sale, service, or brands of alcoholic beverages, then it's okay. But if there's a change in that, we need to report it. To me, it's I'm not sure what's going on with it.
Okay, I'll look into it, how this effective control has been interpreted by audit staff. It's not our intent to change that. So if I can get some clarity and enhance that definition, I will do that.
This is Amy. I just want to ditto what Marcus is saying, and I'm curious about what role licensing played in this change in this rule, because you report a change in effective control. Well, did you report that effective, and I'm kind of using air quotes, effective control in your original application? Because you asked for officers and directors and managerial control is what you asked for in the application, the original. So now I have a change, or I think I do, and now I've got managerial control and effective control. Matthew, Cherry, you're listening. We had conversations about this with the one share rule that never saw daylight, that had to go in a drawer. But we talked about how Warren Buffett has effective control, even though perhaps he doesn't always be an officer or a director, but he holds 1% of a publicly held company, and obviously what he says people listen to. So I'm like Marcus, I'm confused. Sarah says we should be playing a drinking game for every time I say I'm confused, but this needs some clarity, I think. I appreciate it.
This is Bill DeFore again. What I have an issue with, or just question with, is that in the code 109, the 109 provision on subterfuge and all that, we have always put in our management contracts, if someone is a manager, that the permittee has authority for sales, service, pricing, firing, hiring. So how does that jive with what you're doing here? I mean, I'm not sure I understand why you want effective control, why you want a managerial control. Shouldn't it be what's in the code instead of this?
Do you have any?
I think these are all really good points that kind of have pointed out that we need to maybe go back and look at this and see how it can be clarified, and especially maybe how it relates to some of these other types of agreements that are traditional in the alcoholic beverage industry. And so we need to have an internal discussion to see how this could be written more effectively and maybe just use some of the language directly from the code instead of having these specific definitions.
And if that requires us to pull it off of the commission's agenda for proposal, then that's what we'll do. So, you know, when I drafted this, I wasn't really looking to change the rules that I brought over, but, you know, I'm always for making them better.
And the only reason I bring that up is because if I had put in a management contract and the manager had, they could do operating policies, pricing, purchasing, all that, they wouldn't allow that. So I guess it's 109.53. So anyway, I'll send you an email on that if that's okay.
No, I appreciate that. That's really helpful.
Okay, thank you.
The only other thing I would like to add is that while this rule's being reviewed, if we could take into consideration aims and how we report whatever it is that we report. I'm not fortunate enough to know that yet because I'm not in yet. But when I am, how would this rule relate to aims in filing those changes? Thank you.
I think my understanding, and Joanne, I don't know if you're still out there, but my understanding, Retta, or anybody who knows AIMS better than I do, is that anything that's in your original application, you should be able to, I think, change or update through AIMS. But if it's something, you know, if there's somebody effectively controlling that might not be part of the original application, then I'm not sure how that's going to work. So I'll find out about that. Okay, Marcus, your hand is up. Did you have another comment?
No, sorry about that. I'll take it down.
I only have 6 minutes, so I'm going to go ahead and move to item 5. And if y'all, I'm not trying to cut off conversation. Y'all know that I'm always open for phone calls and emails and all of that good stuff. But we just need to get through this so that people can get to the rest of their day. So this item 5 is the Chapter 41 audit chapter redraft. We did talk about this at our last stakeholder meeting, and I don't think anything has changed significantly or at all. I'm not sure. We may have made a couple of changes based on comments that y'all made last time. But here we are again, just to give you, since it's such a lot of change, to give you a second opportunity to make your comments and ask your questions. And it's a lot. I know that. So, you know, it might be best, you know, if we do some quick comments and questions here, but if you have something on this chapter, it might be best for you to get in touch with me separately if it's not something that needs to be discussed necessarily here today with the group. So the only change was tamper-proof, that's right. So the tamper-proof rule is 4116. So this is the new rule per House Bill 1024. And let's see. So we made some tweaks to the language on that based on y'all's comments last time. So freezing the beverage, putting a lid on it, and leaving the straw out of the lid straw hole. That combination does not meet the standard. And the other issue with this, and I already know about it, well aware of it, is that we have left in that this will apply not only to mixed beverage and private club, but also to really anyone who's selling for off-premises consumption. And we know that there is opposition to that because some of these folks, some folks were not included in the bill, in House Bill 1024. So I'm aware of that issue. We're just leaving it in there for now so that we can get maximum amount of feedback on that proposal. Okay, for clarification, is retailer samples for malt beverages permitted? Okay, Bob, I actually get a copy of this, your questions from the chat, so I will follow up on that and shoot you an email. Tamper-proof, Kelsey says, tamper-proof container in C1 seems clearer now. Thank you. Thank you, Kelsey. We're hoping so. Jim.
Thanks, Shana. Just for the benefit of everyone on the call, yeah, you got my letter. I won't belabor it, but representing the craft brewers on this, but yeah, we just want to see brew pubs explicitly severed out of the rule. I get it that they're sort of incidentally retailers, but there are many other things as well. And the legislature has been very intentional about its treatment of that class of businesses, and we for better and worse, and we'd like to just hew to what the direction they've been going. Thank you.
Thanks, Jim. We do? Goodness, we're scheduled till noon this time. So we do have time for everyone's comments and questions. But we're still, I know everybody has busy days, so we still want to keep it moving. But that said, we have scheduled the time. I was not aware that this is a 2-hour meeting. So with that said, are there additional comments on Chapter 41? Any of the changes that are recommended?
This is Bill before again. I didn't really hear what the Mr. Dow said about the growlers from the brew pub. Is that going to be exempted, or is that something they're working on?
So they would like for them to not be included in the requirement for tamper-proof containers, and because they were not included in the legislation. And we were putting out there the idea that, for enforcement purposes and for compliance purposes, it's just easier if everyone's under the same standard. But we're really just looking for input on that idea. And we're still, jury's still out on whether we're going to recommend that or not to the commission.
Okay, thank you.
It's in the rule, but it's quite possible it could come out just based on the feedback that we get.
Marcus Shorts here. I just note that the rule doesn't cover all the people that sell growlers or these type of alcoholic beverages. So from an enforcement perspective, I think it's going to be real hard saying, oh, you're coming from this place, it's okay. You're coming from that place, it's not okay. To me, it's an overreach, I would say.
I'm hearing y'all on that. If you have, what we're trying to do is make it easier both for people to figure out what they have to do and, what's required of them, and, without having to figure out which, category or type of business and category they fall into. And also so that, our enforcement folks can see with a glance, whether someone's compliant and not have to go in and ask a bunch of questions to figure out whether they're subject to this rule. So if you can think of a way that we can do that, that would not be overreach, or that we could maybe just, if there's anything that you think that we could do by rule that would sort of facilitate that, I would be really interested in your other ideas. But it is definitely hard to enforce something where there's just a container and you don't know what's in it necessarily. And without, having to track someone down and ask them a bunch of questions. So we want to try to facilitate that. So would really like some alternate ideas if you have. Anyone else on chapter 41? Not seeing any hands. If we want to come back to it, we can. Like I said, if we do have the time. So if you think of something later, we can come back to it. But for now, let's go ahead and move on to item 6. Item 6 is amendments to product displays and enhancement items, advisory MPA 036. And I'm going to actually let Matthew take the wheel on this one. Yeah,
If I sit here, can everyone hear me? Just raise some hands if I can still be heard. Yeah. Okay. So this advisory has not changed a whole lot, just in the sense of its actual substance and the way that product displays and enhancement items are being enforced. Kind of the big changes are the first section has a little bit more background that explains section 102.20 of the code, and then 45.109 in our rules. And then the kind of bulk of the stuff that is somewhat different from its prior advisory is the previous one seemed to have more of a specific kind of hardline standard for 30 days for having these items up and in displays in stores. And one of the things we wanted to do here was kind of make it more clear that that's more or less like a general standard that we look at. And there are moments where a display could be up for more than 30 days if it's something that is seasonal, or because that specific promotion was supposed to last longer than 30 days. And in those cases, even though it goes on for more than 30 days, we're not going to consider that some sort of prohibited benefit to that retailer. I think that's kind of the biggest thing that this advisory has as an update. And I think with that, we'll take any questions.
If you have comments and questions, just unmute yourself, say your name, and go for it. I am not seeing any unmuted people except for Marcus. Or any raised hands. Okay, so it looks like we don't have any comments or questions on item 6, the advisory. Okay. Does anybody want to go back to anything, since we do have the time? If you want to go back to any of the things we were talking about before, or if y'all want to just go ahead and call it a day, we can do that too. I'll leave it up to you. Okay, well, I'm not seeing anybody that looks like they're wanting to go back to any of the other items. Of course, like we always say, that this isn't your last opportunity to make comments, suggestions for changes. So you can always call me or email me, and we will, take all of that into consideration. We want to get these rules in the best shape we can before they're proposed, so that we don't have to make any changes after proposal. Hopefully, that's always the goal. Okay, with that, I guess we'll go ahead and sign off. And thank you all so much for your participation, continued participation. We really, really appreciate it. It helps so much. Y'all have a great weekend.